Okay, welcome back for some more human resource topics. Today, the course we're discussing is Employment Law by John J. Moran. This is my spring break. We're about halfway through the semester. We're still working on Chapter 5, which is termination. Very big topic and section of human resources, obviously. Okay? So let's jump right into it. Let's see what's happening. The first act we're going to talk about in regards to termination is the Workers' Adjustment and Retraining Act of 1988. Basically, this act requires employers with 100 or more employees to give 60 days notice of any closing or a big layoff. Okay? They do this for a few big reasons. The main reason is it gives state agencies a chance to get prepared. Okay? Another reason is because it gives the mass employee, a chance to also be prepared. Okay? So that's in regards to personal finance, that's in regards to furthering your education, maybe getting enrolled in some type of program through something like CareerLink, state-funded educational program, retraining. It also gives state agencies like Department of Human Services, Welfare, a chance to get prepared for the influx of probably new applications for benefits, medical, food, rental and cash assistance, for example. Okay. Also, it is a chance for basically someone to get their savings together. If you're not going to be working, you're going to need money sooner or later. Okay. So we're going to continue on. With our discussion of the Employment Handbook, okay? The purpose of an Employment Handbook is to provide a reference guide for employees concerning the employer's policies, okay? It's not necessarily law, it's not written in stone, and it's not considered a contract. But it kind of gives the employee a frame of reference, a guideline, basically just something to work with to know what their expectations are in the workplace, okay? It's a good idea to have an employee handbook, okay? Some states may view these procedures as constituting a binding contract by which the employer must abide, okay? So the state might hold an employer liable for something they say in their employee handbook. For example, if you tell the employees they won't get docked for being under 5 minutes late, and they get docked and have a disciplinary reaction to being 2 minutes late, well, maybe an employee might be able to argue, hey, I was told I could do this. Okay? So that is our conclusion for Chapter 5, Termination. There's a few other subtopics in this chapter that I'll probably go back and touch on individually. Some of the Civil Rights Act, some of the ADA Acts, and how they interact. But for now, this is our good conclusion and kind of gives you a good idea about Chapter 5, Termination, and what that looks like in the workplace. Okay, thank you for viewing, and remember, this is information, not advice. I recommend anybody that's having any type of employment legal issue to obviously seek out the help of a professional attorney. This is just a point of reference and information to kind of help you structure what problems in the workplace look like and how to identify which ones are legal or, fairly benign, and which ones are in violation of public policy and are illegal. Thanks for viewing.